While the state and the mother would love for this matter to be resolved today, we also believe it might be appropriate to go ahead and do a temporary order today dealing with current support, establishing Mr. Milton as father of all three children, and resetting the matter for final on July 1st so that we can ascertain more accurate information about his income for the retroactive period as well as current. Today we'll be proceeding with North Carolina minimum wage, Your Honor, which is the same as Texas, and putting it in the non-taxable column based on the mother's information that the father does not pay taxes or work in a job that um, requires him to. And so we'll get to more information on that. Additionally, Your Honor, the state will be offering into evidence Vine link information regarding those North Carolina recent criminal history and something for which Mr. Milton was on community supervision. And the mother will also testify as to that. And her concerns regarding visitation, which up to this point has been sporadic. And apparently, Mr. Milton has only had daytime, hour-long or few hours visits, given the distance between the two families' states distance.
All right, this time, Ms. James, are you there, ma'am? You need to unmute yourself and turn video and raise your right hand, please.
Okay, give me 1 second, sir. Sorry, you're not yet on video. Can't.
If you can't do it, just raise your right hand, ma'am, and we'll go ahead and get you sworn in, all right? All right, Ms. James, you solemnly swear or affirm any testimony you're going to give here today is the truth, the whole truth, and nothing but the truth will help you. Do you hear me, ma'am? Ms. James, are you there? It's not showing that you're muted, ma'am. Yeah, here she comes again.
I'm so sorry about that. Okay, I got it.
All right, raise your right hand, ma'am. Thank you. Do you solemnly swear or affirm any testimony you're going to give here today is the truth, the whole truth, and nothing but the truth will help you?
Yes, sir.
All right, ma'am, the official on the oath. I'm gonna go ahead and let the state call you as a witness. The state's looking at, well, I understand y'all would like to make this final. That sounds like there are a lot of question marks on this one that's going to require the court to set this up as a temp and come back in July and try to finalize this based and get some further information going on this one. But this time, I'm gonna let the state call you, and then at the end of the hearing, if there's anything else you think I need to know, ma'am, I'll let you tell the court so long as it's relevant and to what we're doing here today. So I'll let the state go ahead and call you as a witness at this time. Thank you.
Thank you, Your Honor. The state calls Miss James. Ma'am, what is your full name?
Lexi Elaine James.
Who are the children in this case?
Josiel Milton, Layla Milton, and Mia Marie Lola Milton.
How are you related to them?
I am the birth mother.
And ma'am, who is the father of each of these children?
Jael Darius Milton.
And ma'am, at the time that each of these children was born, and that would be in 2012 and 2014, correct?
Yes, ma'am.
You were not married?
No, ma'am.
And was Mr. Milton present for the births of all three children?
Yes, ma'am. We were in a relationship at the time, and he was there at the hospital.
And for at least two of your children, the state has the birth certificates showing that Mr. Milton is listed for your twins. Is that correct?
Yes, ma'am.
And for your older child, he also signed the birth certificate, even though we don't have a copy today?
Yes, ma'am.
And since that point, ma'am, has there ever been any doubt in either of your minds that he is the father of these three children?
No, ma'am. It's never been a conversation between us.
And
Denial.
there is, yes, ma'am, and there is no other man who could be the father of any of these children?
No, ma'am. Not at all.
In what state did the two of you have your relationship?
I'm in Fayetteville, North Carolina.
And ma'am, what was it that made you move to Texas with your children?
It was just the relationship was abusive, and I didn't have family, and that's
And when was it exactly, ma'am, that you and Mr. Milton stopped living together?
The twins were about like 6, 7 months, years. Well, 7 months, I'm sorry.
Okay, so it's sometime between 14 and 15.
Yes, ma'am.
And why did you choose Texas since you were fleeing?
Because that's where my family is located.
And ma'am, has Mr. Milton ever come to Texas and visited with the children since your separation?
Yes, ma'am, a few times.
When was the most recent visit?
In September of last year.
And while present, ma'am, has he paid for their needs if they've gone on outings?
Yes, ma'am, but they barely even went on outings, so
And earlier, ma'am, were you able to hear my opening statement to the court?
yes, ma'am.
Was that an accurate description of the relief you're joining the state in seeking today?
Yes, ma'am.
And so, ma'am, you're comfortable with the court deciding that these will be temporary orders and we should return on July 1st to finalize everything that's in this temporary order and add the retroactive support based on you and Mr. Milton being separated and you not getting consistent support financially for that time period.
Yes, ma'am.
Are you aware of Mr. Milton having any criminal history?
Yes, ma'am.
What does your knowledge come from?
Well, when I was with him in the past, he had a lot of things going on. And then, I always see him on the internet, being in and out of jail. And also from his Facebook page, which is public to the world, you can see he lives that type of lifestyle.
And while I will ask for additional details later, ma'am, you've had an opportunity to see the Vine link information I referred to in my opening statement, correct?
Yes, ma'am.
Your Honor, at this time, state offers into evidence, I believe, the 6 pages from Vine link as State's Exhibit 1.
I don't seem to have that here. Give me just a second, thank you.
Yes, Your Honor. And ma'am, how long had you known Mr. Milton before you and he began your relationship and had the children?
Probably for like 6 months, I would say.
And in that time, ma'am, what is it that you saw or that Mr. Milton admitted to doing for a living?
Well, we were young at the time, so we were really young. So he was in school and everything. And then I guess towards the end of the relationship is when he started selling like marijuana and stuff like that.
And have you noticed any change in his earning ability or what he chooses to do to earn a living since then?
That's just all. I've never seen or heard of him being in a working an actual job, so I don't think it's changed.
And so, ma'am, as far as these temporary orders, you understood that we'd be using North Carolina minimum wage, which is $7.25 an hour.
Yes, ma'am.
And then, as far as you're aware, has Mr. Milton ever paid taxes or done a job that would actually require the garnishment for taxes?
Well, I know he's on probation, so I'm figuring that he's had to have some type of job to, be on probation. This was what I thought. So I'm pretty sure he has worked a job or is probably working a job, has a little side job, but I'm not sure. I don't really talk to him like that.
And any idea, ma'am, about his highest education level or if he has any special skills or certifications?
Um, I don't think he does. I think he just graduated high school and that's it.
Okay. Moving on, ma'am, to your 3 children here in Texas.
Okay, real quick,
What?
Ms. Bongot, I do have the Vine information at this time showing the criminal history based on the testimony. Is there, ma'am, this is State's Exhibit number 1. Is there any reason this should not come into evidence at this time? Ms. James, any objection to court having this information about the father?
Oh, no, sir, that's fine.
All right, State's one admitted. You may proceed, Ms. Bongot.
Thank you, Your Honor. And Ms. James, based on the information that the judge just admitted into evidence, was it your understanding that, aside from the probation you just mentioned, Um, Mr. Milton's history is actually pretty recent. Would that be fair to say?
Yes, ma'am.
Um, what was your understanding of the date of this most recent arrest for him?
Um, I'm sorry, can you re-ask that question?
Yes, ma'am. When did you understand that he just got arrested?
Oh, like when did I just find out?
What
Whenever
date?
the March the 10th, I just figured it out today.
Yes, ma'am. So not even 2 weeks ago, he was in jail and then out again based on a bond being paid.
Yes, ma'am.
And is this something new or something that you've noticed over the course of your relationship with him?
Yeah, this is all the time.
And are you aware of things, what the charges have been?
Yes, ma'am, a few of them.
What do you know of?
I know one charge he had crashed a vehicle into a house, and then his other charge, a lot of them are attempt to sell and marijuana. And then I saw the other charge on the most recent one. It's had something slash heroin slash something else. So he has a lot of drug charges, attempt to sell, having weapons, firearms, and I know there was one. It was a long time ago. I saw someone screenshotted it, and it said busted. And one of the charges was neglect of child. It wasn't my children, so I'm not sure whose child it was. I think it was like his girlfriend's. So I'm not sure what happened, but I just know that that was one of the charges as well in the past.
And aside from whatever he's currently on probation for, do you know if any of those charges resulted in convictions?
I'm not sure.
And so, ma'am, since you left North Carolina and he's come to Texas to visit your children, has he had them for any significant amount of time by himself?
No, ma'am.
What is the longest time you recall him being with them?
By himself, um, probably for like 6, 7 hours.
And what communication, if any, has he had with them since y'all separated?
The kids have phones, so they normally text or FaceTime or talk on the phone.
And so, ma'am, as far as going forward, while I believe you're saying he can absolutely have a relationship with the children, you're not sure how unrestricted it should be given his lack of time with them and the instability in his life.
Yes, ma'am.
Moving on to the financial for a moment, ma'am, how do your children have health coverage?
Through the state.
And are you aware of him having anything else through an employer or private source?
No, ma'am.
And then, ma'am, as far as the income, which we confirmed was minimum wage, you understood that the state would be asking for cash medical of 56 and then current support in the amount of, apologies, ma'am, it left me, something in the 330 range. Was that what you recalled?
Yes, ma'am.
Okay. And then as far as back support, you understood that we'd be looking at that at a final hearing in July.
Yes, ma'am.
But in the meantime, ma'am, you'll be looking for records of anything he's sent to you directly as far as funds since you came to Texas.
Yes, ma'am.
Was there anything else, ma'am, you wanted the court to consider?
Um, not really. I just know that I'm most likely not gonna be able to find, because I don't talk to him like that or none of his family, so I'm not gonna be able to find if he's worked or not. But I just do know that he pays his lawyer a good amount of money, so he's got to be having income coming from somewhere, and he lives a great lifestyle. So yeah.
Okay. And then, ma'am, as far as safety concerns, does he know your current address?
Yes, ma'am. He's been down here to my grandma's and also to my house. So yeah, he knows the current address.
And do you have any problems with your address being listed in the court's order?
No, ma'am.
And if you move from your current address, are you comfortable updating him in the future?
Yes, ma'am.
And right now, how do you and he communicate when you do?
Just off of phone calls or text message.
Okay. And apologies, ma'am, as far as the current support, for the three children, it was 360. And then if we don't change anything in the final, it would step down to 300 and 240 as each of your children turned 18 or graduated from high school.
Okay, yes, ma'am.
Thank you. Your Honor, I pass this witness.
All right, Ms. James, I'm looking to go ahead and set this up as a temp. I'm looking at going ahead and naming you sole manager conservator based on the court's concerns of what your testimony is as far as what the father does for a living. It appears to be well, something that's not you did well, it may or may not be legal. But the bottom line is the circumstances of the numerous arrests and the charge, even though I don't have notes to show there was conviction, that there was a neglect of a child circumstance. So under Texas law, if there was a conviction for that, I cannot name him as a joint managing conservator until we confirm one way or the other what all the convictions may be one way or the other. I'm going to go ahead and name you temporary sole managing conservator, him possessory, give him electronic access to the children. That's the way y'all been doing it. But that's it until further order of the court. And at this time, I'm looking at just going ahead and ordering child support based on the minimum wage presumption. But the court will entertain something different at the at final if we can find out something differently, or I'll even look at deviating since it's taken so long, or we can to get this done and do a higher child support amount at least for a while to try to help out with the fact that these are now older children, and this matter's been pending almost 6 years now, and it's taken this long just to get this gentleman before the court. I'm going to find that the court has the long-arm jurisdiction. The children do reside here in the state of Texas with his consent. He's actually come to Texas to visit with them. So I'm going to specifically find that the long arm has been met in this matter, and I'm going to go ahead and find that we do have jurisdiction to do what we're doing. Is there anything else specifically that you need me to rule on, Ms. Mongat?
Ruling on non-disclosure and the need or lack of need for it at this time.
Okay, well, the mom says she's okay with giving him the information at this time. He already has the information. I'll ask her at final, does she going forward, would she not want to keep him up to date with that information? But for right now, I'm going to go ahead and not do non-disclosure and just go ahead and go where we are at this point.
Thank you, Your Honor. I think you've ruled on everything I need.
All right, then. All right, ma'am. Ms. James, I'm gonna go ahead and let the state prepare this order. I'm gonna reset this matter to you said July what now? I'm sorry.
First, Your Honor.
Okay, reset to 7/1, and we'll see. And at that time, man, we'll take up the issue of back child support and repayment of such, and try to get this thing set up so that we can start getting you some funds. Hopefully, that'll pay. But obviously, that's going to be a little. Well, we'll see what happens when it happens. All right. So, at
Yes,
this
sir.
time, Ms. James, do you have any questions?
No, sir.
All right. All right. Thank you very much, ma'am. May Ms. James be excused, Ms. Bongat, do you need a back and breakout?
Break out briefly, Your Honor.
All right, ma'am. I'm gonna go ahead and let you get back in the breakout room, Ms. Bongat, and you're free to go. Thank you, ma'am. Good luck to you and the kids, and we're off the record.
Your Honor, the DNA test results have come back confirming that Mr. Knight is a child's father. Recently, the parties submitted an informal settlement agreement for final orders. The parties are requesting that they be named joint managing conservators without a primary conservator. My understanding is that if the court does not approve that, and they understand that the court may not, that would be a contested issue with each parent wanting to be named the primary conservator. Regarding possession and access, the parties in the informal agreement were requesting 1 week on, 1 week off for the parents, so 50-50 possession. Regarding child support, the parties are requesting, oh, Your Honor, regarding possession and access and conservatorship, the state is requesting that that the court name one of the parents the primary joint managing conservator in accordance with the court's judgment and appropriate orders for possession and access. Regarding child support, the parties are requesting that neither parent be ordered to pay child support. The state is requesting that the non-custodial parent pay guideline child support with possibly an appropriate small deviation based on the possession and access schedule, if warranted. Regarding health insurance, the parties are in agreement with the child remaining on the government healthcare program, with the non-custodial parent paying 4.5% of their gross monthly income in cash medical support. Your Honor, given the nature of the requests for the parents, the state is requesting that this hearing be reset to a docket where time permits for a longer hearing.
All right, then let's get some testimony from the parents. Let me find out what's been going on and what this child is. This is a 1-year-old child, barely, and the request that, as I understand them, I want to find out what the history's been and how, and what the circumstances are, and I'll definitely look at setting this on as far as a special setting, and I want to see whether or not the circumstances warrant me appointing in that light to represent the child in this matter. Determine what they think is in their client's best interest. So are both parties in the courtroom now?
Yes, sir.
Okay.
Yes, Your Honor.
And Your Honor, this is Chris Hamblin. I represent Mr. Vincent Knight, and if you would allow me, I'd like to give you a brief opening. I'm the one that drafted and circulated the agreement for the parties.
All right, Mr. Hamlin, go right ahead.
Thank you, Your Honor. A little background, Your Honor. So, child is 2 years old. The parties, I believe, mom submitted SAPSR orders to the AG. Mom is married to an individual who's incarcerated, so he was the presumed father, but we were unable to get in contact with him in November. So that's why we did genetic testing, even though I don't think anybody can test who the biological father is. Actually, since the birth of the child, my client has kind of been the primary caregiver and the majority of the possessor of the child, but the family unit has been practicing basically a week on, week off and co-parenting type pattern since the child was born. And so the parties agreed to bring in an ISA, or you want to call it a parenting plan, that's in accordance with 153.007, which allows the court to deviate from the standard possession schedule if it is in the best interest of the child. And that's why we drafted the way it is. The parties agreed to JMC. They both agreed that nobody would be primary, but to facilitate, to make sure everything is in line with the Texas Family Code, they're both geographically restricted. I think the geographic restriction is also in accordance to what the law does. It's by Bell County, Williamson County, and contiguous counties. For clerical purposes, which I've done this many times in the past, mom's residence will be the residence used for enrollment purposes and medical records. The parties requested a week on, week off exchanges on Sunday. They have a little bit of an extended summer where they get a block of 2 weeks, obviously reset provisions in their standard holidays, ensuring that the child has equal time with both parents. Both parents agree that nobody would pay formal child support to the Attorney General. They just pay for the child when they have the time with the child. But of course, because the child is on government-based insurance, that my client, Mr. Knight, agreed to pay the minimum standard for the Medicare directly to the AG to ensure that that's getting paid. And then we had some miscellaneous provisions on claiming the child as a dependent on taxes. But overall, Your Honor, it's my argument in this case that this is in the best interest of the child. This is what the parties have been following. It complies with 153.007 and with the Supreme Court and Ray Lee, that we're asking to be permitted to move forward with drafting the final orders in pursuant to the ISA parenting plan. If the court is not inclined to sign it, then I am in agreement with the state to reset this for a contested hearing. But I just feel like it'd be inappropriate to bring in a contested hearing and sling mud and drag the family unit fighting over primary when it seems like everything is going quite well and productive as it stands. But that's all I have for Your Honor.
All right, Mr. Hamlin, here's the deal, sir. Yeah, I've never been a guy that, so many times this 50-50 doesn't work very well. It's been my experience. But the bottom line is it does work sometimes. But I would like to go ahead and I really don't want to set this for a contested, but I do want to go ahead and perhaps we'll go ahead and point it at Lyden to do an investigation, confirm everything that you and your and both parties want to do, and confirming that this has been the circumstances for the majority of the child's life, and that they seem that they feel that would be appropriate going forward. Then I've got no problem with it. Okay, I just need to have some eyes and ears out there that are independent of both parties and would only care about what's in the best interest of their client, which will be the 2-year-old's child at this time. So instead of setting it for that type of contested final hearing, I would like to go ahead and make a temporary order and temporarily make them both joint managing conservators, give neither the right to decide domicile. I'll let them still work everything out as is, as they've been doing. But I'm looking at going ahead and appointing Ed Lyden to do an investigation and make recommendations that confirm that the parenting plan that you're requesting is going to be in their client's best interest. Do you have a problem with that, sir?
I don't necessarily have a problem with that, Your Honor. I mean, I think the parties are in agreement. If you didn't enter temporary orders, I think maybe I'd have an issue with it. But I think if I'm understanding right, just for my own note keeping, temporary orders, JMC, no primary designation, the possession schedule that's in the agreement, no child support. Obviously, my client will pay for the minimum for the
Cash medical, right?
Okay. And then in the interim, a guardian ad litem will be appointed.
Correct. And everybody's in Bell County, correct?
No, Your Honor. I believe my client is in Williamson County, actually, but on the side of the Bell County side of Williamson County, if that makes sense to you. So.
Yeah. There's I forgot which town it is in Bell. There's a town that's right there on the border. Half of it's in Bell, half of it's in Williamson. And believe me, over the years, people have gotten service wrong so many times.
Yes.
So
I've been a perpetrator of that problem before, to be honest with you.
All right then. Anyway, but everybody's one's in Williamson and one's in Bell, correct?
I believe that's correct.
All right then. Mr. Coach, I'm looking to go ahead and appointing Allison Kuzak as the ad litem in this one, guardian ad litem, and to confirm that the circumstances are in their client's best interest. Obviously, I'll set this up. I'll go ahead and set this out for. I know Ms. Kuzak's going to leave at least 60 days or so, so I'm going to set this out for sometime in May or early June for a final and give y'all a special setting on that. But I anticipate if the circumstances are as the council has delineated to the court, then I will probably have no problem going forward with that. But again, I always want everything. I want my I's dotted, my T's crossed, because I don't want to have to see this thing again this time next year because everything's falling apart because everybody's got a new boyfriend and a new girlfriend. Okay, so yeah. So so at this time, Mr. Hamlin, can you get out your calendar, because I'm going to be looking at setting this up. And Mr. Kosher, is there anything else you want to ask the court to do as far as a temporary order? Like I say, I'm looking at going ahead and making that order, that their agreement attempt, but coming back in 60 days or so and confirming that as a final.
Your Honor, for the since it's a temporary order, are you requiring a geographic restriction on residents?
Oh yeah, definitely. Everybody's on a dual geographic restriction. So obviously it's Bell and I'm sorry, which party is in Bell and which party is in Williamson?
Your Honor, Mr. Knight is in Williamson County, and I believe Mother, Ms. Jimenez, is in Bell County, but I do not want to misrepresent that fact to the court, but I believe
that's correct. Bell and contiguous covers Williamson, and I'll go ahead and just for right now make it Bell or contiguous counties, and so obviously that will include Williamson, and without having all the way down to Travis, where nobody can afford to buy a house anymore. But we won't go into that. So yeah, so let's go ahead and look at some dates here.
Your Honor, could I ask a couple more questions?
Yes, sir.
On the issue of child support, is that reserved for final?
Oh yeah, that'll be reserved for the final hearing in case we do not go with the no child support amount, or if I do go ahead and do the math, see whoever makes the most money and order somebody to pay the difference. You know, there's all kind of different ways I can look at that. So, but I will reserve that issue. Next question, please, sir.
Allison Kuzak. I wasn't sure how to spell Kuzak.
Okay. Well, let me bring up my, because I was going to say Kuzesek, but hey, I don't want to lie to you. I've known Miss Kuzak for 20 years, and
Beg your pardon, Your Honor. I
Yeah.
can get him that information.
All right then. All right. Zoom calendar does not want to work today. Okay, there it is. Right. All right, let me see. This is the 20th, so let's go after May the 20th. Let's see. Okay, Ms. Kuzak is good on Wednesdays. And looks like I've got a special setting slot available on Wednesday, the 28th of May. I got all afternoon. I got a morning one. The morning one's already taken, but the afternoon for May 28th is fully open. What's your schedule look like on that day, Mr. Hamblin?
I got lucky, Your Honor. I'm fully available on the 28th of May.
All right, then. What I'll go ahead and do is reset this for a final hearing on that. We'll deal with any and all issues. If anybody needs to come in before then, obviously you can file necessary motions and we'll get that in before then. But I'm going to go ahead and make a special setting for that day, give the ad litem the information and let her know that and give her your information. And obviously she already knows the state's information. The mother is not being represented. Is that correct, Ms. Jimenez?
That's correct.
All right, Ms. Jimenez, where is she located? Oh, I see her there. Ma'am, you there?
Yes, sir.
Okay, ma'am, you're what we call a pro se litigant. You technically represent yourself. But right now, I'm going to go ahead and give the child a lawyer. The lawyer is going to investigate both. Well, under the family code, she's going to investigate both households, confirm all that you're requesting, and making sure it's all in her client's best interest. Most times, parents do what's in their children's best interest, and 99% of the time, okay, I won't say 100%, but 99% of the time they do. But every now and then they don't, and she's going to confirm this and see that this has been what's going on. Will work going in the future. Both of y'all fully cooperative, and see whether or not that's going to be the case. And if it is, then obviously I'll go along with this agreement. But if it's going to turn into something different, then obviously we can deal with something different. And like I said, I'm going to technically set this for final, final on that date. But this can turn into a further temporary order. Things have changed on those before we get there. But at this time, ma'am, since you don't have a lawyer and you represent yourself, do you have any questions or is there anything you think I need to know, ma'am?
No, sir.
All right, then. Like I said, does the state have your permission to give Ms. Kuzak your contact information? In other words, your email and your phone number, ma'am, so she can contact you.
Yes, sir.
All right, good enough then. Thank you. All right, folks, I'm going to go ahead and set this
Your
up.
Honor, I'm sorry. One question. This is Mr. Hamblin.
Yes, sir.
If the ad litem reports that everything confirms with what the agreement is and everything looks fine, does this court allow me to maybe file a quick motion that everybody's in agreement to it and be able to just save parties time and money and bring final orders on that instead of having the hearing on the 28th?
Yes, sir. If Ms. Kuzak says everything's good, we're ready, they can all sign off on something. We can get it on a general docket and get it done even earlier. But for right now, I want to save that slot just in case.
Of course.
Because it's family law. Hey, things change. Yeah, things change over a weekend. Okay, so yeah.
Understood, Your Honor. I just wanted to be as efficient as possible.
Yes, sir. And I understand you have to save your client some money. So
thank you, Your Honor.
All righty, Mr. Kosher, anything else, sir?
Just want to make sure. So non-disclosure is also reserved.
Yeah,
correct, Your Honor?
Correct.
Okay. Thank you, Your Honor.
All right, anything that was planned for is all reserved for a final. Like I said, just to confirm everything else. All right, thank you both very much. I'm gonna go ahead and make that Zoom code right now. That way I won't forget, and I'll have that out to my assistant and the AG's assistant, Ms. Walker, as soon as within the next 5 minutes, and you'll have that code and everything else set up. Please, and then make sure. I'm sorry. And I'll make sure Ms. Kuzak gets your information, Mr. Hamlin, and be in contact with you and your client. And Ms. Jimenez, she'll be in contact with you. Give her a week or so. All right, she's a busy lady. She does the pro se clinic here in Bell County, so she's got a couple of days where she's completely out. But Wednesdays are always a good day for her, and hopefully, like I say, she'll be in touch with you by sometime about next Wednesday, sometime next week, the 28th, 29th, something like that. So thank you.
All right, thank you.
All right, now I'm looking at May, not March. Sorry about that. Anyway, let me go ahead and make that Zoom code. And for right now, we're off the record, and I will see everybody next time. Thank you.
Thank you, Judge.
Not a problem.
I will tell you that the DNA order is pending, I believe, and then we also were amending the original pleading to add the
Right.
issue of non-disclosure. So I think, and also I think we wanted to clarify what Ms. Garcia's role as ad litem would be in this case. It's a little, as you say, it's not uncomplicated.
And could you remind the court, please? The parties were married. That there was a divorce in Mexico, and the order did state that there was no child or children born of that marriage. Is that correct?
That's correct. And I think in the original hearing, that came to light, and we had the divorce decree from Mexico and also the translation admitted into evidence. And I think you had asked Ms. Rodriguez, by the way, her name has changed, I think, from Garcia to Rodriguez. You had asked her if she had signed that order and, or that decree, and she stated she had. And I think at that point was when you decided to, order the DNA testing. Also, the father had asked for DNA testing in his answer.
Okay. All right, then. And again, I'm not sure if there was a default decree or an agreed decree. I'm sorry, my high school Spanish is not sufficient for me to read that document. So yeah, it's not going to go there. So at this time, I'll go ahead. Is there anything else? And I'll let the ad litem make her opening. Thank you.
Sure. Not at this time, Your Honor.
All right, Ms. Garcia. So now I got you in this. Yeah, well, these circumstances. What's your opening, please, ma'am? Thank you.
Yes, Your Honor. It's my understanding that there is an appointment that's been set for the father to do a DNA test. And that has not occurred, so I would assume we could not go forward until we know what the results of that is.
Right.
However, aside from that, I haven't had any contact with him. I don't know if he's still here in the States or if he's gone back to, I think he's from Mexico, back to Mexico. I don't have a good phone number for him or anything like that. I believe my office sent out a letter to him, but I haven't gotten any contact from him. So I haven't been able to do that part of the investigation. And I guess I would also, I want to make sure with the court and clarify that is my role simply to follow up with the DNA results and see what type of possession and access is appropriate with the child, or if the court would prefer that I also do other investigations such as, I don't know if there was a conflict of law issue or anything of that nature, if the court could clarify that as well.
Well, for right now, I don't need to look at. I don't think I need to look at a conflict of law circumstance, but I do need for you to do the follow up and make sure that this is all taken care of one way or the other. Hopefully, we can figure that out. We can hear from the mom and see if she's had any contact with him, whether or not she knows whether or not he's in the States or back in Mexico. And we'll obviously, again, I'm probably looking at going ahead and let the state set up the DNA testing already. Let's see if he's going to show up. But if he's not in the United States, that might be a problem, obviously. So we'll have to take this one as it comes, and let's get some testimony from the mother to see what she knows at this point. And like I say, he filed an answer, so he's submitted to our jurisdiction. So no matter what, we can do what we need to do, but we need to dot our I's and cross our T's. So at this time, Ms. Rodriguez, are you there, ma'am? You need to mute yourself. Turn on your video. Yes,
Hi,
ma'am.
good morning.
Good morning. Anyway, ma'am, go ahead and raise your right hand and let's get some information from you, okay? You always swear affirm your testimony you're gonna give here today is the truth, the whole truth, and nothing but the truth will help you.
Yes,
Do you still swear, ma'am? Okay, you're under oath, and I'm going to let the state guard the witness and let the ad litem ask you some questions, and hopefully we can get some answers here today. Thank you. You may proceed.
Thank you, Ms. Rodriguez. I believe in your testimony in the previous hearing, we'd established that that you are the mother of Jesus Garcia, correct? Oh, I'm sorry. Did you raise your hand?
You can take the hand raise thing down, ma'am. You can go ahead and turn off the video. It maybe help with the bandwidth, and it won't be such a delay. We're getting a little bit of a delay on you right now. Thank you.
All right. Are you able to hear me, Ms. Rodriguez?
You're muted, ma'am.
Yes, I can hear you.
Okay, excellent. So at the last setting, I believe you testified you're the mother of Jesus Garcia, correct?
Yes.
And what is his date of birth?
10/1/16.
Can you repeat that? I'm sorry, I don't think I got all of it.
10/1/16.
Thank you so much. And who is the father of that child?
Eduardo Reyes.
Okay. When was the last time you spoke with Mr. Reyes?
Since our last court date.
Okay. How many times have you spoken with him since then? I'm so sorry. Did you hear the question, ma'am?
No, I did not.
Okay. I guess we don't have the greatest connection. So the question was, how many times have you spoken with Mr. Reyes since our last setting?
Just that one time.
One time. How long ago was that?
February 20th, I believe, was our last court date. So a month, I believe.
Okay, month after.
No, it was the day of our last court date.
Day of okay. Do you know if he is still in the United States?
I do not know. I just do know that he comes and goes. But as of now, I would not be able to tell you for sure.
Okay, Your Honor, I think at this time I don't have any further questions on this.
All right, thank you. Ms. Garcia, your witness.
Yes.
Yes, ma'am. Do you have any phone number that you could provide me with that I could attempt to contact him?
Yeah, I have the number that we last had interaction with, so I can give that to you.
Okay. I'll let y'all do that in a breakout room and not here on Zoom.
Yes.
I mean, not here on YouTube. So I'll let y'all take care of that after the hearing. You can go ahead and ask your next question, please. Thank you.
And you indicated that you're unsure if he is in Texas or if he is in Mexico at this point?
Correct.
If he were to go back to Mexico, do you have any way of knowing an address or a family member or a way to contact him over there?
More than likely, yeah.
Okay. Okay, and is that something you could give me whenever we do talk after the hearing?
Possibly.
Right. Pass the witness.
All right, guys. Anything else? Any other questions, Ms. Hopkins?
I don't, Your Honor. Do I have the court's permission to provide Ms. Garcia with the divorce decree, the Spanish language, and the translation?
Yeah, of course, no problem. That's already in evidence. Yeah, just give her a copy, not a problem.
All right, thank you, Your Honor. Sorry, that's all. I have no further questions for the witness.
All right then. All right then, folks. Obviously, like I said, this was again a little bit different. So what I'm going to go ahead and look at doing, and let's go ahead and let Miss Garcia see if she can talk to the father. Let's see if he'll show up for these DNA testing. Let's see if we have to try to get a DNA test in Mexico. Hadn't done one of those in years, but I've done them before, so I know it's doable. So we can see about doing that if necessary. But again, we're gonna dot our I's and cross our T's. Give him 45 days notice at last known addresses. So if we need to go ahead and do a default, we can go ahead and do a default. And if I need and at the next hearing, if we need to discuss a conflict of law, whether or not the court has the right, and I think I do, to go ahead and fine paternity if he doesn't cooperate, even though there's that divorce decree from Mexico that says there were no children born or adopted of this marriage, that seems to be problematic and incomplete. So anyway, how far out are you looking at setting this one then, Ms. Ms. Hobbins? I know that you said the first testing has been set up. Is that correct?
Right. The order, I believe we've issued the order. Ms. Garcia, have you received any indication as to the date?
I thought that there was, but I'm not seeing it in my file right now, so there may not have been a date set.
I
So
have,
you already done yours, ma'am?
I have one for mine for the 26th.
Okay, well, the norm is we can't default him or find that he's not cooperating until he has at least 3 opportunities to do it. So if he's got one set up this month, and they'll set up another one next month, and maybe one in May, so we can come back and look at this sometime in June to see whether or not this has been done. If there's actually been done, then obviously we can get this done ahead of time. But I want to give it enough time frame so that the 3 could be set up and either done or missed before we come back and start trying to possibly default somebody or come back and try to find that someone's the father based on the fact that Texas law requires if you don't show up, then that's prima facie that you are the bio parent, and the court should find such. So so like I said, this is March, April, May, so I'm looking at June. Ms. Garcia, do you already have a setting sometime in June with us?
Let me look at my calendar, Judge. I'm sorry. Let me pull it up.
I got y'all listed as the 10th, and I'll resend that just to make sure you got it, okay?
Okay. Thank you, Your Honor.
All right. All right, is there anything else then, ma'am?
Not on my part.
Okay. All right, anything else, Ms. Garcia?
No, Your Honor.
All right, Ms. Hopkins?
No, Your Honor. Thank you.
All right, folks, let's see if we can figure this one out, and I'll see everybody back on the 10th. And if it works, the best of all worlds, he'll show up, take the test, and we can proceed and not worry about it. So thank you both. Thank everybody very much. And I'll go ahead and sit there, make sure that code gets out right away. We're off the record. Thank you.